The Honorable, the Supreme Court.
Again, thank you all very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Appeal of H.D., case number 25 AP 292. Representing the appellant, the Department for Children and Families, is Attorney Timothy Connors. Representing the appellee, H.D., is Attorney Mary Ellen Griffith.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant. Please come on up. And if you would, for the record, before you start, introduce yourself and identify yourself.
Good morning. May it please the court. I am Tim Connors, appearing on behalf of the appellant, Department for Children and Families, Economic Services Division.
Thank you.
We ask this court to reverse and remand a final order of the Human Services Board, which in our view misunderstands the canons of statutory construction in analyzing the application of an 80-day housing limit made applicable to the Vermont General Assistance Emergency Housing Program by the fiscal year 2026 Appropriations Act, or Act 27. Determining the appropriate framework for managing the 80-day cap is particularly important to the department because the issue is central to managing one of the most important benefit programs for the department, emergency housing.
Yeah, can I don't mean to interrupt you right away, but could you expand on that a little bit? I think I saw in the briefs, there are hundreds of cases that are pending that have this specific issue involved.
Yes, because every case, every emergency housing case that comes before every application requires the department to do an analysis to make sure that every person that applies has money in the bank or days available to them for housing. So the continuing harm to the department here is that they're being subject to this ruling in doing that analysis. And the issue is that people that potentially aren't entitled to housing are getting housing.
So, I'm sorry, are there hundreds of cases?
330 since July 1st where this issue has come up, yes.
Thank you.
Is the sole issue the starting date of the emergency housing voucher?
Well, in addition to mootness, yes, the sole issue is the starting date of the look back period, which is when do you start the look back period? Now, the legislature, when they initially enacted this set of rules, or the statute said you look back no further than July 1st, 2024. And the question is, did that date get updated when the new big bill was passed in 2025?
Doesn't it give a clear date for people to know how many services they have? Saying it starts on July 1 and you get 80 days from there as part of the emergency housing?
I think what it says is I think it's important to look back at the history here. Now, prior to July 1st of 2024, there was a separate set of rules. We were emerging from the COVID period at that time. And so what the legislator said was, when they implemented a new set of rules, they said, look back no further than July 1st, 2024, when counting those 80 days. Now, when the department implemented rules to support that legislation, they specifically stated that that look back period, not looking back beyond July 1st, 2024, would start on the day the application was made. So as we got out into the out years, you would look back a year from the date the application was made. And so when the big bill was implemented this year, they merely cut, paste, and copied that same language, and the look back stop date, if you will, remains July 1st, 2024.
How do you look back 12 months that in a way that includes overnights prior to July 1st of the fiscal year? Isn't that what you're doing?
Yes.
And how do you do that based upon the language in your rule? I mean, you call for a reset, I think, don't you, in the rule?
I would say we called for a reset on July 1st, 2024, when the rules changed dramatically. What happened between 2025 and 2026, I should say, in the fiscal years, I want to make sure I'm precise on that, 2025 and 2026 on the fiscal years was that the legislature set the look back stop date at July 1st, 2024 to prevent us from going back to older programs or programs that no longer apply because there was a constant state of flux inside the emergency housing program. And so this stabilized it a little bit. That set the date as July 1st, 2024. When the legislature included that language in the fiscal year 26 big bill, they merely instructed the department to cut, paste, and copy that very same language, which included the date July 1st, 2024, and the rule that stated that they would look back 1 year from the date of application. So our position is that the look back period is not tied to any fiscal year, any calendar year. It's tied to the date of application looking back 1 year. So as we got into fiscal year 26, we begin to look back with a stop date of 24.
But don't you run into the law regarding that prohibits retrospective application of the law unless the legislature expressly says so?
I don't believe we do, because when you look at the two sets of rules and the two laws for fiscal year 25 and 26, the old law is the same as the new law. So we're not taking away a vested right. We're merely continuing, and this is the first time that in consecutive fiscal years that we've had the same set of rules. So we're not interfering with a vested right. We're not, as in the criminal context, changing a sentencing guideline in some way. We're merely continuing what was previously done the past year. So there's no vested interest. To do otherwise would be to write something into the law that simply isn't there. Had the legislature wanted to put 2025, they could have, and they simply chose not to.
Mr. Collins, isn't this program designed for Vermont's most vulnerable people to give them a benefit to have appropriate housing? And shouldn't it be liberally construed because of that?
I think it's designed for Vermont's most vulnerable people, but it's also designed for the widest dissemination possible. And so by construing it this way, you're potentially cutting people off that you're giving extra benefits to people that, and you're doing this in the context of a limited amount of funding. When we look at what we did during the COVID era, we removed all of the restrictions on housing. We removed all the limits, the caps. What the July 1st, 2024 program did, if you will, is it set a cap at 80 days and 1,100 total rooms. A lot of the federal money that enabled the state of Vermont to remove those caps went away. And now we're operating and not in a more resource-constrained environment. And in order to manage that benefit and ensure widest distribution, the department thinks this is the best way to do that.
Go back to 80 days without giving a specific start date whenever the application was filed.
The specific start date was to separate from the older programs. The specific start date in the rules right now is 1 year from the date of application.
Am I right in understanding that the rules change again on December 1st?
Well, the rules, that starts the cold weather program where a lot of the rules are relaxed or lifted to account for the cold weather we experience here in Vermont. So yes, they do. The 80-day cap goes away. The 1,100 room cap does not go away. So it is more liberal on December 1st.
So people who have been subject to the 80-day limit and are no longer presently eligible would become eligible again on December 1st.
Yes. I mean, it's difficult to make blanket statements, but yes, that would generally be my
Under a
understanding.
different program, under the winter housing program.
Yes, under a cold weather period, winter housing program, we've used lots of different descriptions, but it's a period of time where those restrictions are lifted and the rules are very much more liberal.
Mr. Garner, there isn't any explicit authority, though, for a retroactive application, is there, of Section E .321?
Not that I'm aware of, no.
All right.
Turning to the issue of mootness in this case, the underlying facts are set forth in more detail in my brief on this matter. But after briefing an argument of the legal issues, the hearing officer reversed the department's denial of benefits on July 28th. Since that time, the department has briefed this case, filed motions, and even with an expedited timeline, the department still hasn't been able to get this issue before the court within the 80 days that this benefit is available to HD. Now, the appellee contends that this
Well,
case.
she has exhausted the benefit according to the pleading that her counsel filed.
Yes, she
Do you
has
agree
exhausted.
with that?
Yes, I do.
Yeah.
So now the appellee contends that this case is moot because she is no longer housed under the General Assistance Emergency Housing Program. Well, this is factually correct. The case is not moot because the central disputed issue in this appeal is capable of repetition yet evading review, a well-recognized exception to the mootness doctrine where the challenged action, it must be too short in its duration to be addressed. And there must be reasonable expectation that the same complaining party will be subjected to the same action again. As the timeline demonstrates, the department did all that it could to get this issue before the court in the most expeditious manner possible. In addition, the issue at hand in this case continues to evade resolution as the department is being held to the board's interpretation of the law on a daily basis. We've cited numerous cases in our brief, but I would point to State versus Schaefer and State versus Tallman as two cases that are very similar to our current situation in that the aggrieved party intervened, which was the press, if you will, to get access to criminal documents, charging documents in criminal cases. But what was happening is that the cases resolved before the aggrieved party could get their issue addressed. And that is our situation. We feel this is a continuing harm to the department because we aren't able to give out the widest possible distribution of this benefit to the public. And there is one other case, Muhammad v. Fletcher Allen Healthcare, 212 Vermont 64, which is remarkably similar to this case, in which the appellant was not able to get their issue before the board before the benefit was distributed. At this point, I would request that to reserve the remainder of my
Sure.
time for.
Okay, thanks very much. We'll hear from counsel for the appellee. Please run up. And again, before you start, please introduce yourself and identify your client.
Thank you, Your Honor. May it please the court. My name is Mary Ellen Griffin. I represent the appellee in this case, HD. For better or for worse, this case is moot. It is undisputed, as Chief Justice made clear, that HD has used up the 80 days in this case. This is under a one-year budget bill. There is no way this issue will reoccur. There is no live controversy between adverse litigants here. That is undisputed. If this court grants an exception to mootness in this case, I would ask that you please make it symmetrical so that it can be claimed equally by people who need emergency housing as by the state. Whether or not it is moot, however, the decision of the Human Services Board should stand as it was correct. On the merits of my case, my argument has three parts. First, the decision was based on the plain language of the fiscal year 2026 budget. The plain language controls here. Second, the state's argument about the rules should be rejected because rules cannot supersede the plain language of the statute. And there are no rules here. The rules were never promulgated. Finally, the state's argument that that retroactivity can be implied by reference should be rejected. The presumption against retroactivity is deeply rooted in our jurisprudence. For these three reasons, the decision of the Human Services Board should be affirmed.
If I might interrupt, and I'm
Yes.
sorry to do so. If you'd go back to the mootness point, why isn't this a situation that is capable of repetition, but will evade review? It seems like people have been working as quickly as they can to get this litigated, but it hasn't been able to be done within the time frame.
In order to find capable of repetition yet evading review here, I think this court would have to overrule its decision just last year in INRI SS. A capable of repetition yet evading review analysis is a person-specific analysis. It requires that the complaining party be likely to face the same situation again.
We
In the-
said that in Page as well, I think.
Yes.
But isn't that the case here?
No, HD is the complaining party. She is the person who filed the appeal to the HSB. She is never going to see this situation again. She's used her 80 days under the statute. The statute will expire at the end of June. She will never face that situation again. In addition, she doesn't even live in Vermont anymore. She's moved out of state. She doesn't live here. This issue will never reoccur for her. The other cases that the state is worried about are other cases for other people under separate sets of facts. They have declined to consolidate those cases before the Human Services Board, claiming that each of those stand on their own 2 feet with a separate set of facts that have to be litigated separately. If they want to appeal other cases, they need to appeal those other cases to the state, to this court. The INRI SS case controls this outcome. In INRI SS, it was a very similar procedural posture to this one. The applicant for emergency housing was challenging a 30-day period of ineligibility, also a very time-limited issue. The denial of her benefit was reversed by the hearing officer in a recommended decision, same as in this case. By the time it reached this court said it was moot. Even though she was still homeless, still needed emergency housing from the department, and had serious questions about the general administration of periods of ineligibility as a basis to deny, this court held very clearly that the exception to mootness did not apply to her. If you're going to make an exception to mootness for the state here so that they can have the guidance of this court in how to administer emergency housing, guidance which would be very useful, but it is not within this court's jurisdiction typically to issue an advisory opinion. This court has also repeatedly and even recently rejected adopting a public interest exception, which is really what the state is arguing for here. They're arguing that this is an important matter of public interest, which it is. But it is an issue that should be and will be taken up by the legislature this year, and that is where that issue belongs. There should not be an exception to mootness here. The case is moot whether I like it or not. If you're going to make an exception to mootness, please make it so that both people who need emergency housing and the state have equal footing to seek guidance from this court about the administration of this very important program.
If the legislature takes action, when will that occur? We've got a period now where we're about to enter into the cold weather period of entitlement to benefit. Will this be done on the other end of that?
But based on prior years, it seems very likely. For the past few years, the night limit has been changed either by a budget adjustment act for a couple of years and then last year by the executive order. So while there is an 80-day limit, it is entirely speculative as to whether it will ever apply to anyone else. On December 1st, the 80-day limit goes away because of winter eligibility. Winter eligibility will end on March 30th, but it's very speculative as to whether we will still have that same 80-day limit at the other end of winter eligibility. For the past few years, the Budget Adjustment Act has adjusted that, lifted it. Last year, the executive order by the governor, Executive Order 03.25, lifted the 80-day limit for families with children and people with acute medical needs like HD. HD has
Well, there's a dispute, isn't there? I mean, if you write about mootness, perhaps we don't talk about this, but there's a dispute as to whether or not the governor's emergency order actually impacted the 80 days, whether it extended beyond 80 days. Isn't that right?
No, that's not correct. The governor's order quite explicitly lifted the 80-day limit. He said, I'm waiving the 80-day limit for the balance of fiscal year 2025 for families with children and households with someone with acute medical needs. So HD qualified because she has acute medical needs. She has stage 5 kidney disease. She needs dialysis. She has a port she has to keep clean for the dialysis. She needs to use a wheelchair. She lives with her adult daughter who is also disabled with severe cognitive impairments and epilepsy. So she was determined by the governor to be among the most vulnerable, and he lifted the 80-day limit for the balance of fiscal year 2025. The question is whether days received prior to the effective date of the fiscal year 2026 budget can be counted against the fiscal year 2026 budget. The budget language is very clear. It says only days under this section count against the 80-day limit. Council had said that the July 1st, 2024 date was somehow in the legislature, but I think he misspoke. The July 1st, 2024 date does not appear in the language of the budget bill at all. The language of the budget bill is 80 days under this section. Under this section pertains to emergency housing to be provided in fiscal year 2026. That's what E 3.21 is for.
That starts July 1, 2025.
Yeah, fiscal year 2026 starts July 1, 2025 and runs through June 30th, 2026. So the date, so E321 is for providing emergency housing to eligible families in fiscal year 2026. Days under this section providing emergency housing in fiscal year 2026 are limited to 80 days per 12-month period. In addition, the introductory sections of the fiscal year 2026 budget bill support this interpretation. The fiscal year 2026 budget bill is explicitly to provide appropriations for government in fiscal year 2026. There's a specific section, A102C, that says all narrative portions of this bill apply only to fiscal year 2026 unless otherwise stated. There is no otherwise stated in this bill.
And when we get to FY '27, it's reasonable to suspect that the legislature is going to address this concern.
The legislature would have to set new eligibility. The eligibility guidelines expire as of June 30th, 2026. So whether the program will look like it has for the past few years, or whether they will change it, that's changed, I think, 9 times since the pandemic. The emergency housing program has had a lot of issues, and the legislature has changed and changed and changed it, trying to address those issues. That's partly why we're back at the Supreme Court again this year with other issues related to the administration of emergency housing. But as in INRI SS, where this court held that you can't give us advisory opinions about how it should be issued, this case is also moot. This court should reject the state's argument that its proposed rules can supersede the statute. Rules, even if there were any, cannot supersede the plain language of the statute. And the plain language of the statute controls here. Everything else is just noise and distraction. But more importantly, the department never promulgated the rules. This is entirely on them. It is true that the fiscal year 2026 budget commanded them to apply those rules. And they had assured the Legislative Committee on Rules that they would, in fact, adopt those rules. They went back and forth. They proposed rules that the Legislative Committee on Rules said were contrary to legislative intent. They revised those rules. The legislature said, you're going to apply those rules that you worked out with LCAR. And then they never actually sent them to the Secretary of State. We don't know why. They've never given an explanation as to why. They haven't restarted the rulemaking process. There are no rules. That is undisputed. That was the testimony of their witness at the Human Services Board. There is nothing there. They have argued in their brief that you could incorporate the rules, that the reference, you shall apply the rules, was somehow incorporating it, but there were no rules. There were no rules when Act 27 was signed. There were no rules at the time of this proceeding. There are no rules now. The legislature can't incorporate something that doesn't exist. They could give something that's not a rule the force of law by saying, we're giving this procedure force of law. That's in the Administrative Procedures Act. They could do that if they wanted to. They didn't do that. They told them to apply the rules that they had promised LCAR that they would adopt. In any case, again, that doesn't really matter. Rules can't supersede the statute. Here, the language of the statute, the language of the fiscal year 2026 budget bill is super clear. And as this court has, as we've talked about a little bit already, the law, what they're asking for is a retroactive application of the 80-day limit. And laws cannot be interpreted to apply retroactively unless they are so explicit that you cannot have any other interpretation possible from those rules. This is fundamental to our jurisprudence. This is fundamental to our democracy. Due process requires that people know what the laws are so that they can conform their conduct. That is why there's such a presumption against retroactivity. The legislature can make things retroactive, and they did, in fact, in Act 27, make parts of that bill retroactive. But they did not make E.321, the part regarding eligibility for emergency housing, retroactive. The language just is not in there, and retroactivity cannot be implied. I'm just going to look at my notes for a minute and see if there's something else. In closing, I would say that the language of the 2026 budget bill is clear, it's plain, it's dispositive. The legislature funded 80 days of emergency housing under this section, a section that covers only fiscal year 2026. The department has argued that the rules supersede the statute, but rules cannot supersede a statute, and there are no rules here. Finally, retroactivity should not and cannot be implied. If the legislature had intended that section to apply retroactively, it could have and would have said so, and it did not. We must assume that that is intentional. The board correctly interpreted the fiscal year 2026 budget bill as applying only to fiscal year 2026. Its decision should be affirmed. Under existing case law, however, this case must be dismissed as moot. HD has used her 80 days and she no longer lives in Vermont. There is no live controversy between adverse litigants, and there is no likelihood that HD will ever face this situation again. Thank you.
Thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes and 31 seconds remaining.
Counsel?
Thank you. The
Collins,
depart,
I just have one quick question before you begin, and that is, if you were to prevail, the department were to prevail against HD, what would be the remedy?
remedy would be relief from the continuing harm. It would be stability and knowledge that the rules are being applied and applied appropriately as the legislature intended. And then relief from the continuing harm of having to give benefits out to people that aren't eligible,
But not to HD.
but not HD. Yeah, HD has used her for days.
So you'd have no specific remedy against HD, you'd have remedy against other individuals.
One could imagine a remedy against HD, but I don't know that the department would pursue that.
What would be the remedy?
A clawback, of the money spent for the housing, but I doubt that that would ever happen. In fact, feel strongly that would never happen.
Thank you.
I think I just want to mention that I agree that this is a plain language situation, and in the plain language that's in the big bill in Act 27 in Section E321F of Act 27 entitled General Assistance Emergency Housing, the legislature mandated that the Commissioner for Children and Families shall apply the General Assistance Emergency Housing Rules approved by the Legislative Committee on Administrative Rules on March 13th.
Yeah, but isn't counsel correct that those were never promulgated?
He is correct, but they're not taking the rules. The time to have challenged those rules when they weren't implemented would have been in fiscal year 25. They're taking the language that's in the rules
Yeah,
approved
but
by.
the Administrative Procedures Act is Title III, I forget the section, requires the legislature in its action in the statute or in the act to be very express about the application. And that is not the case here. And in addition, you guys didn't send the rules that the legislature's Committee on Administrative Rules approved. You didn't send them to the Secretary of State, which is what's required for promulgation. So how do you deal with all that?
I think it's Section 835A or B that you're referring to, Justice, and that's applies strictly to rules or rules that are implemented. In this case, we're not talking about rules. We're talking about specific language that was cut, lifted, and placed into the law and then was properly enacted as law. So we're not dealing with rules anymore. We're talking about the language that was utilized and implemented by the big bill.
But the language you're referring to is language that refers to your rules, isn't it? Isn't that the language you're?
It's language that that refers specifically to, and I would look at cases like the Jam case that's in our brief. It's specific language, specific section. It's the rules as approved by LCAR. So we have to assume that the legislature
So
knew.
what you're saying is that you didn't need to promulgate those rules
Yes, that's what I'm saying, Your Honor.
because of the way the language was cast in the bill, in the Act 27.
Yes, Your Honor. Yes, because that language was specifically cited to.
So are you telling us this was a calculated choice on the part of your agency not to promulgate the rules?
I can't speak to that, Judge.
No. Okay. Thank you very
Thank you.
much. Your time has expired. Thank you both. Please call a conclusion of the hearing.
That concludes today's hearing.